Hello, everyone. So we will get started. I want to be mindful of many of you who are in the East Coast, then it may be to get into that time where you're starting to get hungry. I know I'm getting hungry and I'm sitting in Dallas. So we'll get started right away. So this next presentation or portion of the presentation is going to be discussing more about, what happens when things go wrong. And as attorneys, we wish we would get retained, and we often do, on a proactive stance, with companies worried about, enforcing our compliance, setting up our compliance programs. But oftentimes also as attorneys, we get retained when things went sideways. So that's the next portion of the presentation: enforcement and penalties, and what kinds of things you can be doing to make sure that you decrease your potential exposure, your legal exposure, your reputational exposure, and overall, like, just ensuring your compliance is healthy. Next slide, please. So when we're dealing with customs violations, and I noticed when we were reviewing the registrants, I noticed we have a fair number of exporters. So now everything that Tony and Derek have covered, you're all experts in customs by now. But typically when we're dealing with customs, there are a lot of differences from the export posture, right? And I'll try to emphasize that to you as I go through the presentation. But one of the biggest differences is the penalty statute with customs. So 19 USC 1592. Typically, when customs is assessing penalties, they're going to look at your level of culpability. Now, it doesn't mean that other agencies don't sort of already do it, but it's not ingrained in a statute per se, right? So when we're looking at 19 USC 1592, we're going to look at whether your violations were with knowledge, whether you were negligent, or whether you were grossly negligent. That's what customs is going to be looking at. You're not supposed to be importing merchandise, obviously, providing false statements to the government. You're supposed to use your reasonable care, and I think by now you're familiar with that concept. And you're not supposed to be omitting material information from the government, right? So those are the kinds of issues that 1592 will look at. And what are the types of errors that we see oftentimes? Valuation errors, and Tony talked about it extensively. Misdescription of merchandise. We see that a lot in cases where people are saying that they don't qualify, that they don't fall under an ADD, for example, an anti-dumping order. And so to avoid any kind of issues with customs, they say, oh, my furniture is not bedroom furniture, it's kitchen furniture. So then I'm not under an ADD. Or when people try to be creative with their classifications and they don't want to pay a certain amount of duty, so they say, no, I'm not under this HTS code. My shoes are not textile, they are plastic, or whatever the case may be. So misdescription of merchandise, misclassification of items, evasion of ADD, CVD orders, improper country of origin declarations or markings, and improper claims for preferential tariff treatment. So when you're declaring your your USMCAs or any kind of foreign trade agreement or preferential treatment, those are common 1592 violations. Now, something that we often, and actually I just got a call yesterday, and we've been getting a lot of these, and it just kind of tells you in terms of industry, sort of where things are going. But I got a call yesterday, and I thought it was interesting to mention it. We oftentimes are asked, who is responsible for the customs violations? And yesterday I had an interesting call. Somebody just calls out of the blue and asks, who we're importing something, but we're not the importer. We don't think we are anyway. He doesn't even seem to know if he is or not. And he says, well, if the items that I'm buying that I don't think I'm importing, I think a broker, he called it the forwarder, is importing it. If they're subject to ADD, CVD, I'm not responsible for that, right? Or if they're not declaring the right country. And so, it kind of tells you about the levels of culpability, because at that point, somebody already kind of has some knowledge of things happening. And I'll discuss that more in the next slide. But it also tells you about, who's responsible for the import. So technically, the importer of record is responsible, and that's typically what we see in the customs regulations and in customs enforcement cases. The importer of record obviously has the highest level of exposure. Having said that, we've seen cases where, especially when we have conspiracies or aiding and abetting unlawful importations, things like that, that customs will go after other parties, whether it's the ultimate consignee or brokers themselves, or any other third party that knows there's a violation that is happening. That will also get in trouble other parties, not just the importer of record. So that's very important to keep in mind in terms of your potential liability. Obviously, you're the importer. You want to make sure you clean house, that you have a healthy checks and balances within your organization, but also understanding what other parties may be doing. Even if you're not directly the importer of record, there could still be some potential for liability. Less so, but still out there. Next slide, please. So we talked about three different levels of culpability. Fraud. Fraud is the highest level of culpability. It will have the highest penalties. It's also the hardest thing to prove. For the government to prove fraud, they have to show that the party knew. And, if you watch Law and Order and all this, more criminal type cases, proving knowledge is very difficult, right? So oftentimes, unless the government has clear evidence that the party gave an order or took an action and the party knew this is a violation of customs law, it's going to be difficult to prove that level of knowledge. Gross negligence. That will be the case where the party probably should have known. I always say it's more of a self-blinding situation where parties, may know that their products likely fall under an ADD, but they don't really want to ask because they don't want anything to change. So you should have known, you should have taken some reasonable care steps. That's gross negligence. That's going to be like the in-between category, not as terrible as fraud, but worse than negligence. And negligence, that's where most of the customs violations that we see, we fall under, or at least we claim and we argue that we will fall under this bucket. You failed to exercise reasonable care. As the importer record, you failed to exercise reasonable care. You misclassified. You may not have done extensive research on your rulings, or you may have misunderstood something, or you were lacking training for your workforce. Things like that put you in the negligent category. Now, in terms of the penalties, obviously, fraud is going to be the highest. Negligence is going to be some of the lower penalties that we see. Now, something to keep in mind, when we're dealing with customs, it's a civil agency. And if we're ever dealing in a case where, and I have some slides on prior disclosures, if we have any reason to believe there's fraud, there's a very careful assessment that must be conducted, because even having, for example, a prior disclosure with customs wouldn't necessarily mean that customs wouldn't refer that case to DOJ. So it's often, a very careful analysis in determining how to proceed with those kinds of disclosures. So, what's the likelihood of the government finding out what happened, and all of these various factors that go into it. Every time I meet with people that have issues with, customs violations, the number one thing to do right away is stop the ongoing conduct, right? So taking corrective steps right away. So that also goes into, if you're on the defensive, if you're doing a prior disclosure, or if you're not doing one and later have to defend an enforcement action. Next slide, please. And actually, from the previous slide, I should have mentioned, sometimes people also ask, well, we determined that we have, classification issues, for example, but we determined that the classification analysis doesn't change, that there's no revenue impact. And it is true that, practically speaking, customs tends to look at cases, or if there's more enforcement actions, if there's loss of revenue. I think Derek mentioned at the beginning of the presentation, customs is only second to IRS in terms of collecting revenue for the government. So it's very important. Having said that, even for statistical purposes, they want the correct information being declared to them. So it doesn't mean that if you have classifications, for example, that were incorrect, that you just because there's no loss of revenue, that there wouldn't be a potential for an enforcement action. So that's always something to keep in mind as well. So the statute of limitations for customs violations is 5 years from the date of the import. Now, interestingly, for fraud, the statute of limitations is 5 years from the date of discovery of the fraud. And date of discovery of the fraud in this case will be discovered by customs. So if customs doesn't discover the fraud until many months later, that's when the statute of limitations will still be, it will be fair game for the government to go against your company. It's very important to keep in mind that that's why we always say if you don't need to retain records after a certain period of time, it's best, to not have them. And it's very important to always go back to record keeping policies in making sure that if, that you're not maintaining things that you don't by law are required to maintain, especially with situations like this with the statute of limitations. Next slide, please. Now, in determining whether customs goes against the company for a penalty, for example, they will look at various factors. And in some cases, we wouldn't even recommend a prior disclosure, for example, if the errors are reasonable errors, right? Like if it was a gray area in the law, if the company had received incorrect information from customs, because those are the kinds of mitigating factors that customs will use in determining a penalty, right? How new was the importer? Was there any contributing fault by customs? Maybe you received some incorrect advice by Customs and Border Protection. It doesn't happen often, but it happens. Actually, when I was a young associate, that was my first case that I handled by myself 100%. That was a year out of law school, and we had a situation where somebody had met with an import specialist, and the import specialist, they were importing bags, if I remember correctly, from Vietnam. The customs import specialist helped them classify verbally, nothing in writing, but they helped them classify. They had several meetings, and the classification provided was incorrect. Now, many years passed. I think like 4 years after, that import specialist wasn't even with customs anymore, and the company had been relying on that particular classification. So those are the kinds of things where you can defend it. And in some of those cases, you may or may not want to do a prior disclosure. So if the error is not reasonable, if we're looking at negligent, gross negligent, and then fraud a little more complicated, you may want to do a prior disclosure to obtain mitigation of penalties. And that's very important to emphasize, because sometimes, we, especially when we're dealing with smaller importers, with prior disclosures with customs, something very different from the export side is that you actually have to make a payment. Typically, at the end of your prior disclosure, customs will issue a bill, right, for the duties that you owe. So part of the factors that you have to look into whether you do a disclosure is your ability to pay the duty owed, right? In addition to many other factors, right? Like, again, what is the likelihood that the government could do an investigation? What is your history with the government agency? What are other underlying risks that you have? What if you start making a lot of corrections and that in and out of itself alerts the government? So there's a variety of factors that we look into. So the prior disclosure, we do prior disclosures because you obtain mitigation of penalties, not of duties. So that's something to keep in mind as you decide to move forward with the disclosure. Having said that, mitigation of penalties can be a very significant incentive for you to go through the pain and suffering of doing the prior disclosure. Now, prior disclosures, another key difference between an export voluntary self-disclosure, for example, will be you can do, so you have a 5-year look back because we have the 5-year statute of limitations, but you can also do, for example, a stat sample, right? So and it has to be approved by customs, but it allows you to, typically we select 100 to 120 entries, and it allows you to project the loss of duty and the impact to your 5 years worth of transactions. So that's actually, in terms of saving time and money in conducting the investigation, that's very critical. It also allows us to do offsetting, meaning in cases where companies underpaid duties, let's say you have valuation issues or classification issues, so you ended up underpaying. In some cases, and we see this actually quite often, they also overpaid, right? They misclassified, not just on the underpayment, but sometimes they classify and they overpay. So you're also allowed to offset. So that's one of the unique aspects of it. In addition to the fact that, for example, on the export side, it's more about national security, and there's no payment owed to the agency unless there's a penalty. So common examples of violations, and typically what leads to a prior disclosure: undervaluation, overvaluation, I just mentioned that. Same misdescription of merchandise, some of the same things that we see in violations of 1592. That's exactly what leads to the prior disclosures. Evasions of anti-dumping or countervailing duty, also a big one. In those cases, typically we see very high duties owed. Again, so it goes back to your assessment of conducting a prior disclosure or fixing your problems and moving forward with that one, taking that risk. Very important when dealing with prior disclosures. Any party can submit a prior disclosure. Typically, we're seeing the importer of record doing the prior disclosure, but you can have customs brokers, shippers, foreign suppliers getting involved with a PD. We don't see it that often, but it can happen. Now, having said that, in cases where you don't do a prior disclosure, that risk assessment analysis that happens also has to include some of these third parties. And I'll discuss later in the presentation. We're seeing a lot of cases that get referred to DOJ, or that there's relators or whistleblowers under a different act that submit basically claims to the Department of Justice direct, right? So it also goes into who knows about your potential issues at your company, what kinds of errors you have. And typically we see high risk from brokers, your shippers, sometimes your competitors. So why would you do through a prior disclosure? It's a very complex exercise. It is difficult. It is also not necessarily inexpensive. You will need, most likely than not, you will need external service providers. I know it sounds self-serving, but I typically recommend attorneys involved in a prior disclosure. So why would you go through that? Mitigation of penalties, and we talked about that. Let me see. I'm trying to figure out if I missed anything on this slide. I don't believe so. So Vero, we can switch to the next slide. So in terms of the structure with a prior disclosure, it's kind of similar to the export side in that you can file an initial prior disclosure, which is a simple letter, and it just reserves your right that, hey, I've found some issues, and we're going to conduct an investigation, and we're going to provide our findings. And then from the initial, you have 30 days. Typically, the government is fairly liberal in providing extensions, especially in cases where we have stat samplings that have samples that have to be reviewed and approved. In some cases, if there are multiple extensions, you may get a little bit of pushback, or customs starts getting nervous and they may ask you to sign a statute of limitation waiver. So that's something for you to keep in mind. In terms of the elements that go into a prior disclosure, the type of merchandise that is involved, the entry number, applicable, the dates of import or export, and the ports of import or export. Typically, we mine the data from ACE import reports. That's going to be the easiest. In the olden days, when I first started, we would get the iTrack data. We will get the CDs, we will do the request to customs. So now it's a lot easier. And that's also something that makes a difference when we're dealing with DOJ, not customs, but with DOJ. It's interesting in some of the production of records, they request 7501s, right? So in one of the recent cases that we had, we were able to we, provide an ACE report, sort of saying, hey, we can get you all this data from an actual report that has all the data from the 7501s. The materially false statements, the omissions or acts, and an explanation of how they happened, right? Like what happened with your errors, and the true information that should have been provided. Obviously, when we're drafting these disclosures, we have to keep the levels of culpability in mind. Now, when we're conducting a review for a prior disclosure, we typically are not conducting the reviews that we will be conducting if we, let's say, if we were dealing with DOJ. Because, for example, once things go to that side, they're going to be caring a lot about knowledge. That's how they build their cases, right? So in most of those cases, we're going to be doing production. We're going to be doing, they're going to ask the company to review inboxes of certain employees. And all of that is to prove that the company knew what they were doing was illegal, in violation of customs law. That analysis doesn't really happen in customs, in a customs prior disclosure. So for us to believe that something rises to the level of fraud is typically companies very concerned and employees are very concerned and telling us, they typically have to tell you that somebody knew or they're worried about that level of culpability. A person who discloses violations with customs, again, we do the initial, we do the perfected prior disclosure, and these terms are different from the export terms. It's not a voluntary disclosure, it's a prior disclosure. So the perfected, what we will call in the export side, the final, the perfected disclosure will also tell customs, hey, you can either submit your fees, what you owe in duties, or you can say, hey, customs, I will pay what you believe the duties owed are, and I will pay within 30 days from when you receive, when we receive the bill. There is some strategy that goes into whether you want to pay with your prior disclosure or whether you want to wait. An advantage of paying with the disclosure is that sometimes as counsel, we will calculate it, right? Including any taxes, any fees, interest accrued. And there are things that you can do that are, completely legal, that take into account all the factors, but that will make it easier for customs to get the check and move on, right? Rather than auditing the PD or figuring it out themselves, or maybe potentially expanding the scope, etc. So there is that advantage. But in some cases, there could be some disagreement, even at the stage of the prior disclosure with certain things that you want to wait. For example, in some cases, you do the prior disclosure for certain things that we know for a fact this classification doesn't work. No one will agree with the importer on this classification. It's just not reasonable where they put it, and you include those in the prior. But there may be other ones where it's more reasonable. And so we may not necessarily want to include those, and we may protest the other actions, right? So once you include an entry in a prior disclosure, you cannot protest it. So, we could have, depending on the strategy of the specific facts of the case, we could have a protest where we're saying, government, we disagree with you on such and such classification or on such and such issue, but we are okay with this prior. And then depending on the results of that protest, then we will wait for you to issue a bill, right? So there are a variety of reasons why strategically, sometimes you do want to pay, right? In cases where we're nervous, we say, let's just pay. Hopefully they get too excited with the check and they move on. They don't have to do the benefit for customs in a prior disclosure is, yes, industry comes to them. Yes, industry does all the work for them. And yes, they get the credit for receiving this money, for collecting this money, right? So it is tempting to move forward. And again, in some cases, we say, let's just wait for them to issue the bill after protests are closed, or, after we figure other strategy out, depending on the case. Next slide, please. So this is just some data for you, to keep in mind in terms, I'm not going to go over it per se, but in terms of, the number of audits that get completed, sort of the penalties, the audits, the total collected from audits, the penalties that are issued per year. And I think it just gives you a good idea of how active the government is. I was actually surprised to see that 20, I was expecting 20 to have way less audits, and it does look like they collected less overall, but they were active in actually the number of audits that they were conducting. So it's interesting to know that even if there's a global pandemic, and God forbid we ever have to deal with something again, customs was still active even in that time. Next slide, please. So in terms of your companies and your individual situations, I always say, well, focus on conducting, and it was covered by Derek and Tony, risk assessments and audits, but also your own internal risk assessments, right? What are your areas of risk? And I always start with, well, let's look at what customs, what are their priority areas of enforcement? Because if you know that you're claiming a foreign trade agreement, and we know that customs, that's a top priority for customs. Or if you are importing from the Uyghur region, or if you have a lot of items that could be subject to anti-dumping, or if you do have anti-dumping and you're having to deal with that, that is just going to increase your level of risk, where we typically recommend having quarterly self-assessments and just health checkups to make sure that when customs comes and knocks at your door, you're ready to support your verification of origin requests, or you're ready to support your valuation. When was the last time your company sat down and reviewed the valuation for customs purposes? We oftentimes receive information from clients like, we have a transfer pricing policy, we're good, KPMG did it, we're 100%, no worries. And we ask, was that for customs purposes? It's a different set of rules, different agency, and we look at different things, like Tony mentioned before. So looking at all these areas, those are the priority areas for enforcement: HTS classification, valuation, ADD, CVD, enforcing trade agreements, making sure that companies truly are bringing items that are, for example, from Mexico or from Canada, not being diverted from China through these destinations. And there are very specific rules of origin and regional value content that has to be reviewed, very technical exercises. You have the documentation, the trail of documents to even support it. You'll be surprised, especially in some of the smaller importers, but not necessarily, they don't have the records. So all of this is going to be extremely important. We are also expecting more and more enforcement. Trade as a whole is becoming a national platform. I mean, now we hear even people on campaign trails talking about trade and paying more attention to trade. I think last month, because it is February now. So in January, there was a letter from Congress to Customs and Border Protection, telling them that they're not doing a good job in enforcing the Uyghur Act for slavery provisions, and giving them ideas as to what they expect to see, maybe expanding to other countries, not just China, maybe expanding the entity list to add additional entities that may be in third countries that could be supporting China's efforts to evade the Uyghur Forest Protection Act. So expect more robust enforcement, especially because we're getting into an era of, we had decades of low tariffs, low customs duties. It was all free trade. And we're getting into an era where we are a bit more protectionist, right? We are going to be having your Section 301 duties that Derek talked about. We're hearing now from various candidates as to whether we're going to expand duties on every country in the world, and whether we're going to do a 60% duty on China. So regardless of the political party, we are getting into a situation where we're going to be more protectionist. And that just means more work for import compliance professionals and making sure that we can support the origin of our products, that we can support the value. Because what happens oftentimes, and we saw it, and it's going to go into my next slides, even when we looked at Section 301, the government was moving quickly to have these extra 25% duties, when in reality, industry was stuck, for example, with supply chain contracts where they couldn't increase prices to make up for that difference, right? So a lot of people, and I'll talk about it in the next slides, got creative, right? So that's when import compliance professionals, when export compliance professionals become very important to make sure that there's a communication between business and having to absorb additional duties that may come. And it's going to become very important for you to continue monitoring priority areas of enforcement. But interestingly enough, and honestly, for most of my career, we didn't have this situation where you also have to monitor, who's gonna be in the White House, and what is their position on trade, and what is their position on added, more import duties, on being more protectionist with respect to foreign trade agreements, and just assessing higher tariffs. Next slide, please. So I mentioned this is quickly becoming one of my favorite areas in customs law, and I'll explain why. But I've been mentioning a lot about the different levels of culpability, and fraud being the most difficult one to prove. And in some cases, we're seeing more cases where we have to also deal not just with customs, but also potential with Department of Justice. So false claims, the False Claims Act is in part the main reason why this is happening. If not the main reason, why, pretty high up there. In the past, in my career, I have seen cases where customs would refer priors that they thought, hey, there's potential for fraud here, because that would not, a prior disclosure with customs would not protect you with DOJ. And it is interesting to see, because in the export side, now DOJ has the Export and Economic Sanctions VSD. So technically, if you do your analysis and you decide that that's the best choice for you and your company based on your profile, risk, et cetera, you could theoretically do a disclosure with one of the export agencies or the Economic Sanctions Agency, and also with DOJ, and get some protection that way. We don't have an equivalent under the customs side. And submitting a prior disclosure with customs will not protect you, right? So the False Claims Act comes into play when we have situations where, and typically it started back in the time of the Civil War in the US, and there were a lot of issues with contractors submitting false claims to the government for payment, basically. So there were contractors, and they were misrepresenting information to the government, and they were getting paid. Typically, you will get paid by the government some money. Now we're seeing it in the customs or in the trade world with something that is called the reverse claim, meaning the government says, you misrepresented, you defrauded us, and because of those omissions or misrepresentations, you paid us less money that you owed us, or maybe no money, right? So in the case of customs cases, you misrepresented your classification, you misrepresented your valuation, therefore you didn't pay us what was rightfully ours, and so that's a reverse false claim. What's interesting about the False Claims Act is that it has the quitam component, which means a private individual can sue on behalf of the United States government. And not only that, and that person becomes what we call the relator. Now, as an incentive for the relators typically get part of the recovery. And there have been cases, where they get 10 million, 7 million. I mean, they are big penalty cases. And if the DOJ intervenes in the case, the relator receives 15 to 25% of the recovery. If they decline to intervene, they get 25 to 30% of the recovery. When they file the claim, it's under seal, so you don't know who the relator is. Sometimes you don't even know if there's a relator at all, right? I mean, typically you won't find out until much later in the case. So we're seeing this incentive for, I think there's two things that are increasing the number of these cases. One is we're, for the first time in many decades in our history, we're having higher incidents of tariff evasion because, for example, now we have the China tariffs, right? So people had to absorb them. And yes, unfortunately, in many cases, they got creative with how they absorbed it. And also because there's just more awareness and also, yes, people may be incentivized by the recovery. I was speaking at a conference in Spain last year, and it was funny because one of the Spanish attorneys said, Europe is undergoing some reform and they have a new whistleblower statute. In their statute, they don't provide rewards, monetary rewards to the whistleblowers. So the Spanish attorney, I'm in the panel and he says, that's such an American thing to do. Like you guys are still in the Wild West, like where you had like the reward and, we're most wanted. And if you find them, we're going to reward you. And I thought, well, yeah, there's something to it. But as I will show you in some of the next slides, there are a variety of reasons why relators come forward. Sometimes it could be there's personal liability for the relator, and they don't, their reputation is at stake. They're nervous. There could be some political motivations as well. We've had cases where it's clear that it was more of a political motivation, a competition situation. So there are a variety of reasons. We're seeing this more and more. We're seeing them definitely in the customs. And I'll give you examples of a recent case that we had where we had relators that were employees of the company. And it makes these cases extremely, both from an attorney perspective, interesting, but also very challenging to deal with, because half the times you're working with the relators without knowing that those are the relators, and you need them for the investigation portion of it. So with that, we'll move to the next slide, please. So I mentioned false claims, and you can have a KETAM where basically a relator comes forward, files a complaint. We've had situations where we actually had a case where the company comes, they retain us. Within the same week, we had already sent them the engagement letter. I did ask the client, is there any reason why we need to hurry up? And he said, no. We just, I met with my accountant, and my accountant said he suspects some violations. We want to review. Okay. So we send the engagement letter, and all this happened really quickly. Within the same week, we get CIDs from Department of Justice. So in this particular case, you can still do prior disclosures with customs to protect for 5092, but you already received notification from a different agency that there's an investigation. So even in cases not like the one I'm talking about, where we submitted we couldn't submit because we had already submitted the CID, technically you can still do it. Does it help? I mean, typically what helps the most is it's going to be fact specific. I think it depends on whether DOJ is investigating something that is not all of your universe, right? So we quickly want to analyze your entire, is DOJ thinking that you have a valuation issue, but you also have classification? Is it expansive? Is it not? What is your level of appetite for risk? Costs are also an issue. So we're going to have to review, because False Claims Act is not necessarily going to be protecting you with 5092, although we can negotiate, and we typically always do, and we see it across the board when we're dealing with the settlements. We do what's known as global settlements, where we bring all the agencies. So in this case, we will bring, yes, the settlement with DOJ, and we also want to settle, including 5092 violations, with customs, so that customs doesn't turn around and issue a penalty for 5092, right? So that's going to be something that we definitely want to do. It's a little bit more up in the air whether we do concurrent disclosure, a disclosure with customs while we're dealing with DOJ. That's going to be more fact specific. Again, any settlement should cover both statutes. Sometimes, ironically, when we're dealing with DOJ and false claims, sometimes 5092 could be worse penalties, right? So, we don't necessarily want to point that out either, right? So that's something that goes into the factor and the analysis that we do and how we decide to move forward. Because of the levels of culpability, like 5092 could be worse if we're a fraud. Let's see. We had cases. So the next bullet point reminds me of a case, and we didn't handle it, but I know a colleague of mine handled it, where you can have, and I think I touched on it briefly, you can have a prior disclosure, close the case with customs, and typically that's the end, right? You pay your duties, customs is happy. But we've known of cases, and I don't think it happens very often, where after customs closes the case, there's a quitam for a False Claims Act. So one of my colleagues said that she closed the case with customs, and sure enough, one of the employees was a relator separately with DOJ, and the relator's argument was that the prior disclosure didn't fully disclose fraud. Well, we're never, gonna point out that we've had fraud, but this case was so specific because the employee had the internal knowledge, right? If you think about who has the knowledge of the acts and who who gives orders and how much they know, it's typically going to be internal to the company. So in that particular case, apparently, after they submit the prior disclosure, DOJ starts a False Claims Act after they have paid a multi-million-dollar, under the prior disclosure. Now they had to deal with False Claims Act, that they were not protected under the regular prior disclosure with customs, because that's not going to give you protection with DOJ. So it goes back to, in every case, determining your level of risk, whether you could potentially have fraud. It is oftentimes difficult to tell if employees, believe that the investigation hasn't been conducted thoroughly, or if they think that something is being hidden. So that may not be right away apparent to parties. So that's something that we try to ascertain at the beginning of the case, especially in cases where there's no document review. Email inbox review is difficult. People are not going to come to you and say, yeah, I knew all of it and I still gave that order, right? So it's going to be typically internal. And that's going to be one of the differences, and I think I already talked about it, between DOJ and customs. We had a case where the client was spending a lot of money on having us review inboxes. The government had identified custodians, client employees, requested all their inboxes, their email inboxes. So you have to go through all those emails, like thousands and thousands of emails. And I remember we had calculated everything quickly because we just ran ACE reports and we were like, okay, these are the classifications, this is the value issued, this is what. So we were able to calculate it, very, very quickly. So I have a meeting with the government and I said, well, I've already done all the calculations. Why are we still making this client spend all this money for us to review all these inboxes? And of course I knew the answer, but I was trying to negotiate for them to cut some of the inboxes. And he says, we're looking for knowledge. We're trying to find out if there's something in the emails that reveal this client didn't take it seriously or that they knew about it. And typically that comes through knowledge. Through emails, email communications. So it's always very important, email communications with attorneys, everything labeled as attorney-client privileged, because it comes to a point that you wish, things were privileged or that certain things were not put in writing. Next slide, please. So in terms of, and I know I'm running out of time, so I'll quickly go through some of these scenarios. Some of the FCA and customs cases started with whistleblowers, typically internal knowledge of company operations, accountants, people in logistics for the company. Yes, in some cases, import-export compliance professionals that have very detailed knowledge of company operations. Some cases, competitors, of course. Common scenarios that we see, and I'll go through some of the examples. Submission of false documents, double invoicing is very common in the customs world, misclassification of products, misrepresentation of country of origin, all these various things. But double invoicing is very interesting in the customs world because there are ways of doing it. And we'll go through some of these cases. We are actually seeing it more and more, not just in customs, but also export controls and economic sanctions. The way they bring those cases to the mix is typically we have a government contractor that represents to the government that they're in compliance with the export and economic sanctions regulations. because they make that representation, and if they're not truly in compliance, then the government can say, we gave you government contracts and you obtained money from us, but you misrepresented your compliance. So we've seen one, I think it was in 2023, the 3D, I believe it's called a 3D case. I forgot, 3D Systems, where it was a government contractor. It was an export situation. They were exporting control technologies to China. They were a government contractor, so they made these misrepresentations, and that turned into an FCA type situation with DOJ. Next slide, please. So really quickly, these are just some interesting examples. These are not necessarily the highest numbers. There are cases, if we go back previous years, these are just typically all in 2023. But they're interesting examples for a variety of reasons. So for example, the International Vitamins Corporation case, that was an interesting case because that was a company, and that's a pretty high penalty. The company had received 2 notices of action, and Derek talked to you about notices of action. 2 notices of action telling them, hey, this such and such product, that's not the right HTS code, you have to correct it. So the company will be like, okay, I'll correct for this one product, when consultants had actually told them, hey, the same reasoning applies to all these other products, right? Like the same, you have to move it to every other product, even though they were not the products in the notice of action, is the exact same reasoning. So not only they ignore the notice of action and don't apply the reasoning to the rest of the products, they also ignore the consultants that told them in a report the same 2 notices of action would apply to this line of products. And they go above and beyond to defraud the government, because they also give orders, and this is when emails come, handy for the government. There's communications between them, and one says, hey, we need to destroy this report that we got from our consultant. So as you can imagine, the government, had a lot of fun enforcing this one. So 22.8 million in settlement. And I don't believe, if I remember correctly, this was not a Kitam. The Samsung C&T America, it's interesting. It's just your typical, the company takes some liberty in classifying the product. They say that they're textile, but in fact they were plastic. And given the difference in the material, obviously the correct one had higher duties. So they misrepresented the description of the merchandise was incorrect. Danco Laboratories is very interesting to me, going back to the comment that sometimes we get, hey, people just do it for the money, which, yes, of course, it's a great incentive for people to do it. But there are other reasons, like Danco Laboratories was importing certain pharmaceutical products, and they were a pro-life type of organization that was the relator. So it was a nonprofit organization that submitted a tip to the government that they were mismarking the products. So that's what leads to this action. Again, more of a political belief system type of case, not so much because of the penalty that they could collect on, but more of a religious situation. And Yogi Boy is an interesting, the last case listed. Again, we see this scheme a lot, where they undervalue merchandise in invoices. In some cases, you see straight up 2 invoices, one that we present to customs, the other one the manufacturer in China sends to the importer and says, hey, this is the real one, you have to pay me the real amount. So we see just straight up double invoicing. In some cases, they get more creative, and so they do deductions. So meaning, I believe Tony covered assists or things that have to be added to the price paid or payable. So they'll deduct molds and tools and, a variety of assists, and it undervalues the price that you declare to customs. So this is a great example of that. They were excluding charges for inland freight, design, and quality control tests. So they were artificially undervaluing the products. Now, these cases, if you're familiar with assists, not all of them are very intuitive. Sometimes something goes in, but international freight is out, so there's always the argument that did they actually know that would be in violation of the law, right? So that's something that we will use in the settlement process as well, unless there are emails or something that comes up. Next slide, please. So just to close it out for you, and this was covered by Derek and Tony as well. Take it seriously. Go to have training, have a good compliance program in place, have internal controls, do self-assessments. I typically recommend conduct ACE report, import report assessments every quarter or so. Review 15, 20 entries, review your priority, the customs priority areas. Do we have anti-dumping? Do we use any FTAs? What are our largest classifications? Like what's the number that we use the most? Have we confirmed that's still the case? And do a self-assessment. Double check your brokers. Don't just rely on your brokers to do everything for you. If you do have a mechanism for employees to report potential violations, take it seriously. And I just finished talking about FCA. Ensure that the employees know that the company takes it seriously, that there will be an investigation. Don't give employees reason to contact the authorities direct. And if you do discover violations, consider hiring assistance. But whatever you do, stop ongoing violations as soon as you can. If you continue with ongoing violations, at that point you have knowledge of the violations, and that's what starts getting us into a different level of culpability of fraud. So we want to take it very seriously. And with that, I believe that was my last slide. I don't think I have questions, but let me know if we do. Otherwise, I will let people go to lunch. And our contact information is right there. I did get an email from someone asking about CLE. We will provide information this week on CLE credit, but we received it.